Our second and third cases of the morning are related. As I mentioned earlier, the first of those cases is Shepard versus Osteen Acquisitions Group, case number 2025-16-17. The second case actually the third case of the morning is Wanda Van Dam versus Osteen Acquisitions Group, case number 2025-1602. So as you heard in the beginning, what say counsel about the panels dealing with the panel dealing with the time we have set aside? There are overlapping issues here. What say the attorneys about all that?
Judge Mike Andrew on behalf of Shepard Appellant. I think we'd be willing to split the 20 minutes between me and my co-counsel, Wanda Van Dam.
Okay, and so that would be 1617 and 1602 on the appellant side?
Yes, and we'll be able to get an extra 5 minutes?
Certainly.
Okay.
So you're saying 25 minutes for the combined appellants and 25 1617 and 25 1602, correct?
Yes, Judge.
On behalf of the Osteen Acquisitions Group, are you going to be with us twice?
Yes, Your Honor, I am.
Okay, and if you would just announce your appearance for the record.
My name is J. Christy Wilson, III of J.C. Wilson Associates, here on behalf of the appellant.
Thank you, Mr. Wilson. So you'll be representing Osteen Acquisitions in both of these matters. Do we have, and I guess you're here on behalf of Van Dam, correct?
Yes, Your Honor. Shaz Eric Portello, area PA, on behalf of Ms. Van Dam.
All right, thank you. Is Mr. Hardy represented?
He is not, Your Honor. He has not made an appearance.
So he's not with us today. We have a lot of moving parts by OA standards. This is a lot. So the plan will be 25 minutes, and we will split that up between the two of you, the Clifford Shepard appellant and the Wanda Van Dam appellant. 25 minutes between the two of you. Collectively, how much time would you like to reserve for rebuttal?
We get total of 6 minutes for rebuttal, 3 and 3.
Certainly. So it'll be 19 minutes and then 6 minutes, and then how you break that up, I'll leave to the fine and able counsel. Obviously, that means 25 for you, Mr. Wilson.
Yes, Your Honor.
Any objection to this process?
I have none.
Any objection to the court doing it this way? All right, please proceed. On behalf of the first case, Shepard versus Osteen Acquisitions, case number 2025-16-17. And for the difficult work of our marshal, you got all that 19 and 6 for the first as to the appellants, correct?
Yes, sir.
Okay. Please proceed when you're ready.
Good morning. May it please the court. Michael Andriano on behalf of the Shepard appellants. This court should reverse and remand with instructions to dismiss Osteen's amended complaint under Florida's anti-SLAPP statute, section 768.295, because the trial court failed to correctly apply the statute's plain language as written. I'd like to quickly focus the court on what happened here based on the four corners of the complaint. This case does not concern a purely private commercial dispute.
Before you get started,
Sure.
Curiosity and the cases may bear this out. Does the statute nullify the rules of procedure? Meaning, are the typical analysis points for a motion to dismiss the analysis points for the court here? Or did the statute change those analysis points?
I think that's a super important question, and I'm glad that we're addressing that this morning. And so the statute was enacted to safeguard constitutionally protected petitioning activities and free speech rights, but requiring the expeditious resolution of those lawsuits. So in Veriker, our Supreme Court aligned Rule 9.130 with that legislative command, permitting interlocutory review of orders denying motions under Section 768.295. And so that phrase, without merit in the statute, cannot be read in isolation from that immediately following phrase, primarily because. And so the complaint must be primarily viewed through the statutory lens. And so while this court certainly reviews the complaint's allegations as it would under the normal motion to dismiss standard, the court must also examine the gravamen of the lawsuit and determine what...
Is that the burden shifting that you're discussing from the second DCA case?
No, Judge Boatwright. We don't believe the statute's plain language supports a burden-shifting framework.
Okay, so you're not arguing that?
No, Judge.
Okay, all right.
And thank you for that clarification. So a trial judge in an anti-SLAPP case, that trial judge, he or she evaluates that whether the complaint and any attachments to the complaint states a cause of action that is not barred by the anti-SLAPP statute. Is that correct?
Correct.
And in making that determination, the court is bound by the four corners of the complaint and any attachments.
Correct.
What about the complaint in this case and any attachments to the complaint would trend towards your view that it failed to state a cause of action? And what about it causes the complaint not to state a cause of action within the four corners of the complaint?
And so under the statute, so that phrase without merit, right, which we've labeled the meritless motive prong, the second consideration, it asks whether a lawsuit was filed in retaliatory in nature because it was triggered primarily or for the most part because of a defendant's participation in those protected activities and is therefore meritless.
What is the protective activities here? What is the protected speech that you're arguing?
Sure. So reviewing the four corners of the complaint, let's look at those allegations together. So the complaint alleges that appellants looked at possible scenarios for bringing legal action to review the City of Deltona's development order, contacted and met with Kelly Chambers regarding challenging that development order, filed and litigated the lawsuit against the city under Section 163.3215 Florida statutes, which is the exclusive method by which someone can challenge the consistency of a development order with a comprehensive plan, sent the demand or demolition letter to Osteen's counsel on the same day the lawsuit was filed against the city, objecting to Osteen's intervention as a party defendant in the lawsuit filed against the city, assigned the claim to Henry Hardy, reposted a newspaper article on appellant's public firm website, and prosecuted the appeal of the lawsuit against the city. So that is the same nucleus of conduct which forms the basis of each claim of Osteen's amended complaint. And those allegations describe litigation-related petitioning, political advocacy, and public commentary on governmental action, the precise conduct that our anti-SLAPP statute was designed to protect.
They don't use that exact language, though, political advocacy. They don't use that in the complaint, correct?
No.
Okay.
No. That is our legal conclusion, right, an analysis that we're drawing from applying the statute's plain language.
So it would be your position that that's a valid legal conclusion from what is pleaded here? Meaning that the legal conclusion from what you just verbalized from the complaint runs afoul of the anti-SLAPP statute?
Yes, Judge.
What about the cases that say that really this is an affirmative defense, this is not intended to be weaponized in a motion to dismiss? What say you about those cases?
I think I know that the statute's plain language resolves that because the statute specifically permits a motion to dismiss to be filed and dismissed for anti-SLAPP purposes. It permits a motion to dismiss and a motion for summary judgment, right? Those are the two motions that are in the plain language of the statute. So if it was an affirmative defense, the legislature wouldn't have included a motion to dismiss avenue.
What about the constitutional implications of that? Is that the legislature getting into the judicial branch? Because as we know constitutionally, the Supreme Court of Florida is in charge of procedures. So is that not running afoul of the constitutional prerogative of the Supreme Court of Florida? Or not?
And Judge, just to clarify, are you asking whether this statute runs afoul?
Well, from what you just said, saying that it could be advanced in a motion to dismiss or a motion for summary judgment, does that run afoul of the constitutional lines between the Supreme Court of Florida and the legislature? Or not? Is that permissible?
I know the issue wasn't briefed, Your Honor. And so generally, I would say no, because the legislature has set forth this constitutionally protected and statutory procedure.
You would agree, I mean, constitutionally, the Supreme Court is in charge of procedure in the courts.
Yes,
You would,
I agree.
So how is that not this, meaning the legislature is telling the Supreme Court, potentially, that this can be advanced in a motion to dismiss or motion for summary judgment? I'm trying to reconcile that in my mind.
Yeah, definitely, I understand, Your Honor. I would say, and I would think whatever policy debates and that kind of analysis might be a task for the legislature to resolve and go back to, not necessarily for this court.
Your point, though, would be the plain language of the statute allows the very thing that you did on behalf of your clients in this case.
Yes. Yes, under that first prong, which is the protected participation, we believe that same nucleus of conduct is all protected activity, which is all confirmed by the allegations in Osteen's amended complaint. Filing a complaint to challenge governmental action is protected petitioning activity. And the statute and the First Amendment protect the right to petition regardless of success, right? So otherwise only successful litigation would be protected. And also, Osteen also makes much to do about appellant's intent or ulterior motives, but a party's intent or motive behind their petitioning or free speech is irrelevant.
Well, isn't that really a matter for a jury, though, or a fact finder, when you start talking about the intent that takes it outside of a motion to dismiss? Maybe a motion for summary judgment might be more appropriate?
I don't know about more appropriate. It's definitely an avenue that could be taken. The main focus here is whether, because the statute allows for review on a motion to dismiss, the main focus is whether the
You're talking about
allegations...
intent, but if you start talking about intent, isn't that really for a fact finder?
Generally, yes, but if it can be ascertained from the allegations of the complaint, then under the statute, a court can decide whether it fits within the statute's requirements. But regardless, a person's intent when they're petitioning or exercising their constitutional rights is irrelevant. And there's Supreme Court cases that generally hold that.
Is it not a component of the statute that it has to lack merit? I mean, that's a term the statute uses, correct?
Absolutely.
So how do you determine if something lacks merit from the four corners of a complaint? Isn't that quintessentially a fact-finding decision or not?
And so we take it back to the plain language of the statute, which instructs us. And so the question is whether the lawsuit was filed primarily because of those activities, right? And so the court must examine what conduct the plaintiff alleges is wrongful. And so the focus is on the nature of the conduct, right, that alleged conduct. If the alleged injury flows from protected petitioning activity under the first prong, then the lawsuit is by definition based on and brought because of that activity. And so the court examines, again, the gravamen of the lawsuit, the specific conduct being alleged, to determine whether the alleged basis for liability is the defendant's protected activity itself. And so, again, the allegations are what matters here, not the labels attached to claims or legal conclusions attached to what actually is being alleged. And so if we take it claim by claim under that meritless motive prong, the tortious interference claims are meritless because the complaint alleges only indirect economic consequences flowing from appellant's protected activities, not any direct, intentional, malicious, or independently tortious inducement of a contractual brief. The complaint admits that Osteen's contract with Ashton terminated because the project stalled due to the underlying lawsuit filed against the city. It also admits that other buyers for the property could not be secured because of the underlying lawsuit filed against the city. But the complaint never alleges the malice requirement that appellants contacted Ashton or any other party to advocate, encourage, imply, suggest that the contract should be terminated or breached by any party. So there's no allegations that show direct or intentional inducement or malice, but only consequences of the litigation itself against the city. And the abusive process claim is likewise meritless because the complaint alleges nothing more than appellant's use of ordinary litigation procedures to challenge governmental action. Petitioning through litigation cannot constitute abusive process merely because it delayed or opposed the development. And as previously discussed, that section 163.3215 provides the exclusive method by which someone can challenge a development order, which is what the Shepherd appellants used here.
Part of your argument, too, is litigation immunity. Is that something you're advancing here today? I know you argued it below.
We would like to focus on the statute, the plain language of the statute, and the requirements under those prongs. And I think my time is coming up.
Well, I think you're at 12 minutes, leaving Van Dam's counsel 7 minutes. But again, I leave it up to you guys as to how you want to attribute the time.
I can conclude. And for those reasons we discussed today, we ask that this court reverse and remand with instructions to dismiss Osteen's complaint.
All right.
Thank you.
Thank you.
May it please the court. My name is
Good
Shai
morning,
Azari.
and you have a little less than 7 minutes. But if do you think that gives you enough time to say what you need to say?
I will do my best, Your Honor, and if...
And we'll evaluate it as we
Thank
move
you.
forward. So
Thank you very
please
much.
proceed, and please announce your appearance for the record.
Yes, Shai Azari from Hartzello Azari, PA, on behalf of appellant Wanda Van Dam. Ms. Van Dam appeals the circuit court order denying the motion to dismiss under the anti-SLAPP statute for the same reasons. This court should reverse and remand likewise for the same reasons that was presented by counsel for Attorney Shepherd and the Shepherd firm. Specifically, the activity which is the subject of appellee's claims here is referred to as the underlying litigation. However, it's very important to note that this litigation was not utilized to resolve private differences between parties. The allegations here reflect classic protected conduct, including community activism, organizing community opposition, and advocating against governmental action, petitioning for redress regarding a public land use issue.
What about the question I asked counsel a minute ago about lacking merit? Isn't that a feature of all this?
Yes, Your Honor.
How do we do that on a motion to dismiss? How do we evaluate whether something lacks merit on a motion to dismiss?
Yes, Your Honor. It's a very important question to this inquiry because those are the two requirements, and there's the and in between the two requirements in the statute. And Florida state courts, as well as federal courts, have held that while not the exclusive way to determine a case is without merit, failure to state a cause of action is one way to determine a case is without merit. Likewise, if a case is disposed of on summary judgment, that is also without merit. And I would point to Lamb versus Univision Communications, Aussie Plenar versus Reach as two Florida cases that suggest that. But directly on point, Mac Isaac versus Twitter, a federal case, as well as Parquet versus CBS Corp.
So those federal cases, based on the lesser federal standard, found that complaints lacked merit on the face of the pleading?
They found that, and I believe it was Mac Isaac, for example, they found that because that particular complaint lacked actual malice under a public figure analysis, which would dispose normally of a complaint on a motion to dismiss, it therefore lacked merit for purposes of, without merit for the purposes of that statute, of this statute.
On the face of the pleading?
Yes, Your Honor.
You would agree, though, typically, whether something lacks merit sounds pretty factual, isn't it? Or not?
No, not according to the decisions from the cases that I just referenced.
Is there a Florida case saying that?
I believe the most on point
And when I
case.
say Florida, not a federal Florida, but a Florida State Court, Appellate Court, or Supreme Court of Florida.
Yes, I would direct the court to Aussie Plenar versus Reach. I can point to that. If I'm going by my recollection, there is under the tortious interference analysis for purposes of a motion to dismiss in that case, they determined that it's without merit. Or, excuse me, they say it's without merit in that section. And I'll pull it up in just 1 second. I apologize, Your Honor.
And that was a tortious interference claim?
Yes, I believe so. I just want to verify I'm not mixing up cases.
And so to understand what you're saying is in that case, based on the four corners of the pleading, the court found that the tortious interference claim and the complaint lacked merit.
Yes, it's page 460 of that case, under the heading tortious interference with the business relationship, where the court then goes through the elements for purposes of, I believe it was a motion to dismiss. And the third DCA, I believe it's the third DCA, says the trial court correctly determined that this cause of action was without merit, and then goes on, the elements of tortious interference are, and continues in that way. So while not directly expressly saying that, by the nature of the analysis in this particular case, we would submit that that's exactly the inquiry before this court.
If the court agreed with your argument, meaning this panel agreed with your argument, is it over, or would we send it back to give them another chance to replead?
Also, a very important question. So setting aside the constitutionally protected activity, what I'll call the first prong of the analysis, and focusing only on the second prong without merit. In this particular case, as it relates, and I don't want to speak for counsel for Mr. Shepard and the Shepard firm, but as it relates to Ms. Van Dam, the deficiencies that are found within the complaint. So if we're going by the standard, which we would submit is the standard, that if it fails to state a cause of action, it is therefore without merit. In doing so, the legal insufficiencies of this complaint are incurable. For example, the statute of limitations. That is an incurable legal insufficiency. So there would be...
Well, statute of limitations, I know you know this, typically is not something that's resolved by a motion to dismiss. And matter of fact, the cases allowing that are like hen's teeth, but there aren't very many of them because typically you don't have the ability from the four corners of a complaint, unless you have an attachment that may signal a statute of limitations problem. So here, why is that not a question for another day that use Judge Boatwright's parlance, a motion for summary judgment, for example?
Yes. Well, Your Honor, so as Your Honor recognizes, there are situations where it is clear, right? So if the complaint itself, including the attachments, make clear datable publications, for example, in this case, as it applies to slander of title, then, if it's apparent on the face of the complaint, including the exhibits, while normally an affirmative defense, is a valid basis for a motion to dismiss. And in this case, we have exactly that. Some of the allegations, for example, the assignment, the filing of the lawsuit, all of these actions are dated. Some of them are documents attached to the complaint itself. So there is no question here, as opposed to some of the cases that were cited by appellee, where it was a bit ambiguous as to when these publications took place. In this particular case, there's no question that they are outside the statute of limitations, with the exception of the filing of the appeal, which is legally insufficient for other issues.
And as this judge understands the rules of procedure, an attachment trumps the allegations of the complaint, meaning the attachment becomes the complaint to the extent there is some allegation in the attachment that is different from the pleading. You would agree with that, correct?
Yes, Your Honor.
And I believe that's Fledell, Supreme Court of Florida butterfly ballot case, among others. But so to the extent the attachment is contradicts the pleading, then the attachment would be the predominant allegation related to the claim.
Yes,
right?
and to that point, Your Honor, I would point out that the attachments to the complaint, one of which is the actual contract that's alleged to have been tortiously interfered with, the date of the termination of that agreement, which is the exhibit, is prior to two of the other acts that are contended to be the basis for tortious interference, meaning, according to the exhibits, despite what the allegations and the complaint are, two of the allegedly tortious acts happened after the termination of that very contract, which is contended to be interfered with. And I believe that I'm at 5 minutes remaining.
And the court will give you another minute 8, so that will give you 6 minutes collectively for your rebuttal. Thank you.
Thank you, Your Honor.
May it please the court. Quickly, before I get started, you asked whether there was a Florida case citing the provision that was asserted by counsel for Van Dam.
The lacking merit. There is a Florida case?
Well, no, because the Florida case that he cited, Your Honor, as authority for that, there was a finding by the court below, the finder of fact, that it lacked merit. And the appellate court was just affirming the finding by the court below. So
How in the world can the court make a finding of fact on a motion to dismiss? Respectfully, I don't mean that other than I didn't know courts did that in motion to dismiss
I
hearings.
don't know, Your Honor. In that case, though, it was the finder of fact that made that, not the appellate court, which is what counsel is asking this court to do.
Mr. Wilson, I'll be candid, I don't understand that. I don't know how a trial court evaluating a motion to dismiss could ever make findings of fact. And maybe there's some new rule I'm not familiar with.
No, Your Honor, you're absolutely correct.
That's your whole argument here, isn't it?
Yeah, it is. The trial court dismisses if you fail to state a claim under the four corners of the complaint.
Because in this setting, the trial court is not the fact finder.
That's exactly right. Not yet.
So the case you're referencing, was that a motion to dismiss case?
I was just responding to him. He said it was, and there was a finding of fact by the court, or a finding that there was no there was a failure to state a cause of action, which was affirmed by an appellate court. You asked about a Florida case. That's
I did. I find it surreal that on a motion to dismiss, the court would make a finding of fact. But maybe there's, and they can explain it during their rebuttal time. But moving forward, what about the ending argument from counsel for Van Dam that when you do have attachments to a pleading, those pleadings do predominate. They do prevail over the actual words of the pleading. And there's a rule. I mean, if I could pull up the rules, I could tell you the rule that says basically that same thing, that they control. What do you say about that, where you have these attachments to the complaint that, based on the case law and based on the rule, takes precedence over the language of the pleading? What say you about that, Mr. Wilson?
Your Honor, I think that's the law. I would be remiss if I said otherwise. That is the law.
And I just remember Justice Labarga's case, the butterfly ballot case, when he was a trial judge that went all the way to the Supreme Court of Florida, and the Supreme Court said it was attached. And even though they pleaded it was confusing, we can look at it ourselves, and it's not confusing.
That's correct.
But that's the point of that particular case. But so you would agree that's the law, that if there's some attachment contradicts, maybe that's a better way to say it, contradicts the pleading, then the attachment would predominate.
Yes, Your Honor, and we contest the contradiction. The statute of limitations for tortious interference is 4 years. And so we don't.
And I would just say this, Mr. Wilson, in my experience, it is rare to see a dismissal of a complaint on the statute of limitations affirmed by an appellate court. That is rare. But the only times I remember seeing it, there was some attachment that categorically said, yes, this claim started or finished or was completed on this date based on the attachment. And you would say here that's not the case.
No. The attachment they make the most issue, Ms. Van Dam's lawyer makes the most issue out of the greatest issue, is a screenshot of a blog maintained by the Shepherd Law Firm, where they made a statement about my client's property or development being injurious to the community.
Was that appended to the complaint?
It was, and there's a screenshot that the statute of limitations for that, for slander, is 2 years. But there's a screenshot of when that was up and running. And it was a running blog, we contend, of their activities in the lawsuit. And that screenshot date places that posting within the statute of limitations. So I think there's no, as far as we're concerned at this point, there's no issue that we violated the statute of
So
limitations.
what I hear you saying is that attachment, even assuming that attachment is true, and we have to assume it's true, I mean, that's the standard, would mean that the claim was still within the statute of limitations, is
That
what
would
you're
be our
saying.
position, Your Honor. And all of these issues were raised before the trial court, I would point out.
Well,
And-
I understand
and the trial
that, but
court denied the
our
motion.
review is de novo. You agree
It
that's
is.
our review?
Your review is de novo, yes. As you asked counsel for Mr. Shepherd in his statement, is he bound by the four corners of the complaint? Is that what we're here about?
And attachments.
And attachments.
That's important.
Then, absolutely it is.
Okay, please
And-
proceed.
And then he went through his understanding of the case, which is not what is alleged in the complaint. So I just want to take a minute and bisect that for the court's understanding. First of all, we're not contesting Ms. Van Dam's right to make her views expressed to public bodies such as the City of Deltona, in this case, City Council.
And if you were, that would be barred by the anti-SLAPP statute.
It would be.
Well,
Although
why
the
call her,
anti-SLAPP statute, I will say,
excuse me, why call her a community activist and preventing the development and keep her from stopping unnecessary overdevelopment? I mean, why state that in the complaint then if you're not?
that is the position that she has advocated in the community. Her group appeared before the City Council and asked them not to approve my client's development. It was fully aired. The City Council heard everything and went ahead and approved the development. That is not what we're here about. If that was what she had done, we would have no issue. Ms. Van Dam also had a right to go and have her case heard by a court. We have no issue with that either. Her vehicle for having the city's actions reviewed was a petition for writ of certiorari. And if she had followed that, we wouldn't be here today. But what she did, and what we find objectionable and perverse, actually, is the fact that she realized that under Chapter 163, which is the statute under which they brought their action, Mr. Shepherd and Ms. Van Dam, she did not have standing to bring that action. She was not an affected property owner within the meaning of the statute. So what did they do? They went and solicited a party who was a neighbor to my client's development to be their straw plaintiff. That violates, we believe, Florida statutes. It violates the rule of ethics controlling the bar. You cannot solicit a client to achieve your ends, another client. And that's what she did. And that's in our complaint, but also we have it in Ms. Chambers' own words.
How is this different, though, when you seek out someone to advance a class action and you put an ad out there saying that it's our belief that there has been some there has been some breach by fill in the blank, this company or this organization, and you are asking for people that may have suffered injury as a result of that. How is that different than this? And you would agree in the case I'm speaking of, the example I'm giving you very broadly, that would be something that someone could do looking for potential class members or not? Or are you saying that would be wrong too?
No, I think you can look for potential class members by putting an ad in the paper. Where you cross the line is where
That
you go.
happens all the time.
It does. Where you cross the line is where you go to their home and knock on their door and say, would you be a plaintiff? That's what crosses the line, because that's solicitation that is not permitted under Florida law. And you can't do that directly or indirectly through a third party.
Is there a distinction to be made that in the class action hypothetical, the ones sending out the newspaper ad, if we can use that phrase, actually has standing to bring the claim himself or herself, as well as those who may likewise suffer injury?
I am not an authority on class actions, but my understanding is you usually have a plaintiff, and then that plaintiff brings a cause of action that the court feels might have general application across a broad basis, and then the court certifies a class, and then they advertise and bring people in. But that's not my expertise. I do know that when you cross the line and actually solicit in person, that's not permitted by Florida law, and that's what happened here. And they don't have the opportunity at this stage of the game to talk about a different number of different facts than those alleged. Then with respect to the contract, my client had a contract which they were pursuing development of with Ashton, a home developer, and that contract was lost because of this. And the reason that we bring up the assignment is that Ms. Chambers was selling her property. She told them, yes, you can use my name. She didn't go to them and say, hey, I'm being damaged by this. They came to her and said, we need a plaintiff who lives near the property. So can we use you? And she said, yes, you can use my name. They used her name. Then she went and sold her property. And that's where the assignment comes in, because they realized that if she sold her property, she would no longer have standing to pursue her 163 action. And what they did then is they told her, if you're selling your property, now we need to find another affected owner. So they found another affected owner who didn't buy her property. If he had bought her property, that would have been a different story, but he didn't buy her property. He tried to assert, and they, under their guidance, his own cause of action, even though he had not met the 30-day requirement for doing that under.
Why are these claims not barred by litigation immunity? I mean, that's a broad immunity.
Your Honor, I think litigation immunity does not bar actions where there is fraud or manipulation or action on part of the plaintiff that is against Florida law. You can't take the fruit of the poisonous tree and argue
and
litigation
it's been a while
privilege.
since I've done a deep dive in that world. I know there are exceptions. The Supreme Court of Florida, in an excellent opinion by Judge Soud, issued recently in a footnote, I believe, talked about malicious prosecution being something that is not barred by litigation immunity. I don't know that the question of abuse of process has been taken up by a Florida case. Again, that would not be barred by litigation immunity. But my sense of the Supreme Court of Florida is they've been pretty broad in finding litigation immunity with anything related to litigation. Am I wrong about that?
Somewhat, Your Honor.
And that was the takeaway of Judge Soud's case, the breadth of litigation immunity.
With all due respect, Your Honor, I think the court's litigation immunity generally applies to witnesses, the parties to the lawsuit, and those under the jurisdiction of the court.
And those advancing the claim, well, and including the lawyers.
Well, and the lawyers advancing the claim, yes. But when you drag in an outside party, in this case, the day that they filed the lawsuit against the city, it wasn't filed against my client. It was filed against the city of Deltona. The attorney for Ms. Chambers at the time sent a letter, it's referred to as a demolition letter in our complaint. Again, my client was not a party to that action. My client was not under the jurisdiction of the court. He sent a letter to my client's then attorney.
And perhaps the demolition letter may be different, but I mean, I think you started all this by saying the claim that was advanced was different than it should have been. It should have been a different chapter than it was. Isn't that classic? Just making a wrong call on where to advance a claim or how to advance a claim. Isn't that classic litigation immunity or not?
No, Your Honor, I don't think a party has the right to violate the law of Florida, to put themselves in a position of being able to avail themselves of a statutory remedy, and that's what happened.
Well, and I get malicious prosecution. If it's frivolous, if there's no merit to it, and there are 6 bullet points for malicious prosecution, I understand that, but I get it in a malicious prosecution setting, and perhaps in an abusive process setting, but for pretty much everything else, just making a wrong call about where to advance a claim or how to advance a claim, isn't that classically protected or not?
No, I don't think so. Have
you read Judge Soud's recent opinion?
I have not. I'll look forward to doing that. But the situation here, Your Honor, is they knew very clearly that they did not have standing to bring the lawsuit they brought. That's not litigation strategy.
I'm not suggesting litigation strategy. I'm just saying advancing a claim that you take issue with, in and of itself, I don't think that rises to the level of a claim that is not barred by litigation immunity, but maybe there are cases saying otherwise, I'm not familiar with.
Your Honor, I'm not here suggesting that that Ms. Van Dam and Mr. Shepard didn't have a right to have the decision of the city reviewed by a court, in this case, the circuit court.
So they had every right to do that?
They had the right to do that, but they did not have the right to pursue Chapter 163.
Why not?
Because they had no standing to do that.
So you're saying every time someone advances a claim with no standing, they can get sued for that?
Well, if they intentionally and knowingly pursue a claim they know to be meritless and they know that they have no standing, which is clearly what they knew, they sought out Mrs. Chambers.
So what's the tort?
The tort is abuse.
Abusive process?
Abusive process, yes. They sought her out and asked her, they said they needed someone who lived near the property. So,
is there a Florida case saying that abusive process is an exception to litigation immunity?
I'm not sure about that, Your Honor.
I thought I read somewhere that there were no Florida cases saying
think-
that, but maybe I dreamed that up, Mr. Wilson.
Oh, I think there is. Just one. May I have just
There
a
are
second?
cases saying abusive process is an exception to litigation immunity?
I believe there are. I'm not going to sit here and quote a case because but I think when there is an action that is undertaken by a plaintiff that is violative of the law, as we contend was the situation here, they solicited Ms. Chambers personally. This wasn't through an ad or the type of situation you'd have in a class action, because this was not a class action. They were bringing a lawsuit on Ms. Chambers' behalf. They alleged that she was claiming injury and harm when that was not the case. They were simply using her as a vehicle to get standing that they did not have and that they knew they did not have. And when you act that way, when you violate the law, there is case law that says that you, that action is not protected by litigation privilege.
You would agree, though, making a wrong decision about the type of claim to bring is not actionable, just in and of itself. Assuming no scienter or malicious intent, just making a wrong call is not actionable because it would be barred by litigation immunity.
No, I don't think just making a wrong call is actionable. I think
So here you would say it's different because with scienter and malice, they did what they did. That's the allegation here.
that is.
Now, if that's not borne out, would they be entitled to summary judgment?
They may if it's not borne out. We think there's clear evidence that it will be borne out, but that's, yes, if it's not borne out. And that's, I think, why the Supreme Court in the Decker case said, and I'm reading from Section 9 of that, to prevail on any SLAPP claim, a defendant must show that the plaintiff's lawsuit is without merit and wrought primarily because the defendant exercised protected speech or conduct. A judicial determination that speech-targeted lawsuit is without merit may not be possible at the outset of the case and may require the development of the factual record, which is exactly what you said, Your Honor, and which I agree with wholeheartedly.
As to the anti-SLAPP
As to all of the factors that are involved in the lawsuit, yes.
Well, correct. So globally evaluating this complaint, if there is a factual question, that's not for the judge to make on a motion to dismiss.
Correct.
And a motion for summary judgment, as we all know, is no genuine issues of material fact. So if there are genuine issues of material fact, that the court would not grant summary judgment either. But if there are no genuine issues of material fact, then the court could grant summary judgment.
That's exactly right, although I believe the standard has changed, and now you don't just get to say there's an issue of fact or law, you actually have to produce proof that your case has merit.
The whole burden, but I think Anderson, SCOTUS, the decision by Justice White says that if a reasonable jury could make a determination based on the facts presented, then it's not a question for summary judgment.
Right. And, Your Honor, there's a case that comes out of this court. Judge Dauch was the author of the opinion, and that's the Florida Fern Growers Association versus Concerned Citizens of Putnam County. And this predates the SLAPP statute, but SLAPP is discussed in this opinion. And what we had in that case was the fern growers.
So isn't that dictum?
I don't think it is because
It was before the statute.
he addresses the constitutional provision of free speech. And that's what I want to point out to the court.
So he couldn't address something that didn't exist.
He's talking about the constitutional protection of free speech.
No, I understand, but I'm saying if the anti-SLAPP statute didn't exist, he couldn't deal with it.
He wasn't dealing specifically with the anti-SLAPP statute, but he was dealing with the constitutional protection of First Amendment rights. And what he said is that along with the protection of those rights of free speech also comes the obligation not to abuse those rights. And that's the basis of him allowing the case to go, reversing the trial court's dismissal of the case, allowing it to go forward, because the fact situation was there was a group of folks, a community organization, that every time the growers would ask for a consumptive use permit from the Water Management District, they would all file an appeal and run up the time and delay, and that's kind of what we have here. We have a community organization that has decided they're not going to allow any more development in the area, and they're going to fight it. And one of the things that we allege is that Mr. Shepard, with his advertisements, was hoping to bring more and let it be known that he was going to challenge any development. So I think this falls within the
Why would they not
Fern
have a
Growers
right
case.
to do that?
Pardon?
Why do they not have a right to do that?
They do, but at some point, that becomes actionable. They have a right to free speech, but Judge Dowks' position was, in exercising your right to free speech, you have an obligation also not to abuse free speech. You can't go into a crowded theater and yell fire. That's an abuse of free speech. So the question is, where do we cross the threshold where the action of a plaintiff becomes an abuse of free speech? We would ask you to affirm the trial court. This case is not ready for any determination with respect to the SLAPP statute. The SLAPP statute is no merit and primarily brought to challenge or punish someone for exercising free speech. My client is not bringing this action to punish anyone. My client is simply seeking remuneration for the millions of dollars that they have lost while this action was pending and brought. And we believe that it was not brought in good faith. It was brought in bad faith in violation of the Florida statutes. And that in the end, we're confident that the court will find that and that we'll get the relief we're seeking. So we would ask you to simply deny the petition, allow the court to do its thing, the trial court, and they have the right to file a motion.
You're out of time, Mr. Wilson. Thank you.
Thank you. Appreciate it.
Three and three or different?
3 and 3.
Okay, please proceed.
All right. May it please the court. So a lot to address here. I want to try and keep this brief. So number one, this isn't a threshold question here. We're not talking about any lines crossed because the allegations of the complaint show that there was no abuse of any petitioning right or free speech rights. And Chief Judge Jay, going back to answer your question about whether the litigation privilege applies to abusive process, this court has held that it does, as well as the Third District Court of Appeal.
So there are Florida cases saying that an abusive process action would still be viable in spite of litigation privilege?
No, the opposite.
The opposite?
Immunity covers abusive process claims. Or
so
applies
it
to.
would be barred?
It could be barred, yes.
Could be or would be?
It would be. It just says it applies to those claims, and that's on page 64 of our initial brief, those cases.
So, but you would agree, in line with the Supreme Court of Florida and Judge Sal's opinion, that malicious prosecution is not covered by the litigation?
Yes, and I think that's a different question than.
And it's a different claim because that emanates from something before the claim as opposed to something intra-claim.
Yes, Judge. Yes.
So thank you for that. So there are two courts that say abusive process would be covered by litigation immunity.
Yes, Judge.
All right. Go ahead, Judge Bogan.
And so I want to also address quickly the panel's concern about, how do we make these findings? How do we apply this without merit? How do we make this without merit determination? And so courts can make legal findings on a motion to dismiss. And Chief Judge Jay, I recall you brought up the statute of limitations. Sometimes that can be limited to be decided on a motion to dismiss in limited circumstances. So as an example, if a negligence claim pleads an accident happened in 2020, that's the allegation in the complaint, finding that it is time barred is a court making a finding based on the face of the complaint.
But that's Four Corners.
Yes. And so the court, the statute requires a combination of both. It can't just be failure to state a cause of action. The four corners of the complaint is what the courts are required to look at because we're on a motion to dismiss. But it cannot just be a failure to state a claim inquiry. It has to be more than that because of that, primarily because of a defendant's protected activity language that's in the statute.
But then you're superimposing on the Supreme Court's exclusive authority to come up with a rule of procedure. I don't understand that because I thought we started all of this by that question. That
yes,
Judge.
The
standard algorithm in motion to dismiss cases is the four corners of the complaint and any attachments and whether that states a cause of action. And now you're telling us it's a little different than that with the overlay of the anti-SLAPP statute or not?
That was the argument that I had made, that we had been making, and then I made earlier, and then you had asked me that constitutional question, which I know I'm out of time, but may I address that question
please,
a little
and
bit?
I'll give you 3 minutes, but yes, please.
Okay, so let me see if I can try to explain this. Okay, so that legislature's reference to allowing in a motion to dismiss, using that language in the statute, it's an indication that it's not necessarily an affirmative defense, and we know the legislature can create those if it wants to, like a statute of limitations. And so it's not.
So the legislature recognizes that's a potential mechanism in dealing with a claim that may run afoul of the anti-SLAPP statute, correct?
I believe so, yeah.
But back to the analysis point algorithm, it's still the classic analysis point of the four corners of the complaint and any attachments, and whether that states a cause of action.
We don't think it can be just that based on the statute's language. Otherwise,
Florida Supreme Court has said it's just that. I believe, and I don't want to speak for the chief, but that's exactly the point.
It is. And
We read the statute, I'm sorry, Chief.
No.
We read the statute and the rules in harmony. We're not going to
Sure.
read the statute to override the rules.
No,
That's
absolutely not.
the prerogative of the court.
I agree, Judge.
Okay.
I agree.
And the Supreme Court has said just that. And Justice Kennedy decision, normally I could put my finger on, but I know that's been said by the Supreme Court of Florida, that that is our standard. But you're not telling us that some about the statute changed that standard?
No, it doesn't change that standard. It's the best phrasing, maybe like a supplement to it, is that it requires both. You have to look at the complaint's allegations. So we're here on a motion to dismiss, and we're here in that special interlocutory review of orders denying motions under this statute. And so while you're looking at the four corners of the complaint to determine the conduct, it has to be read in combination with that primarily because language. Otherwise, the without merit, there's an and there. And so the without merit and the primarily because concerning the conduct, they don't jive, for a better lack of a term. And for these reasons that we've expressed today, and for those in our briefs, we'd ask that this court reverse and remand with instructions to dismiss Osteen's amended complaint under Florida's anti-SLAPP statute.
Thank you.
Thank you, judges.
Thank you, Your Honor, for the additional
Just
time.
1 minute. He's given you 3 minutes. So
Thank
now you have it. Please proceed.
To directly address some of the inquiries from the court, one of the distinctions that was asked from the inquiries was, where do we draw the line? When does this conduct become okay or not okay? And the Supreme Court of the United States in NAACP versus Button and the Florida Supreme Court in Pace versus State draw that distinction where it's okay or not okay. And the Florida Supreme Court in Pace made clear that allegations of engaging in associational activity in order to further political beliefs and advance other ideals, political ideals, that sort of conduct is protected under the First Amendment. And again, the case is directly on point. I would say Pace versus State by the Florida Supreme Court. They cite NAACP versus Button. They cite in reprimis as two examples furthering public interest issues, or even encouraging litigation, referring to an attorney, all of these
So
things.
your opposing counsel seems to really focus in on the straw plaintiff. So how do you deal with that?
Yes, under Button, under Pace versus State, those labels attached to the conduct are not the true inquiry here. The true inquiry is whether the allegations that are made constitute protected conduct under Pace, under State, under Pace and under Button. And the Supreme Court in Button stated clearly that the state cannot foreclose the exercise of a constitutional right by mere labels, and neither can appellee. So based upon the allegations of the complaint, including that my client is a community activist, that she organized a local group to address and in response to government action, not the appellee's action, but a government review and seeking litigation to seek review of that approval, including fundraising for that, referring to a lawyer, even taking those allegations as true. Those are all in furtherance of political ideals, and under Pace, under Button, those are protected First Amendment activities, and the narrow interpretation that this isn't speech is easily refuted by both of those cases, which group that conduct in freedom of expression. Very, very quickly as well, the Ozzie Plenar case as it relates to the without merit, that is a Florida State case, and that the procedural posture of that case is a motion to dismiss, is an appeal from the granting of a motion to dismiss for failure to state a cause of action. So I would say that that applies here. That's a Florida State case here on without merit on that second prong. And finally,
Was that a factual determination by the court, as I heard Mr. Wilson say?
I don't think it needs to be a factual determination. I think that the court looks at the allegations of the complaint, takes them as true, and determines as a matter of law whether those are protected activities.
You would agree that's not for the court to do at a motion to dismiss, make factual determinations, correct?
Correct. I believe that that's a conclusion of law, taking the facts as true within the complaint, including the exhibits. And just very quickly, the blog post that was referred to, all of the allegations related to this blog post on the website have nothing to do with my client. The complaint does not set forth any of those allegations against my client. And just to be clear, on Florida fern growers, this court rejected only the heightened pleading standard under the right to petition. Not that this was somehow not constitutionally protected activity, but that the pleading standard required for the plaintiff that they were not going to adopt the sham test. That's all that was. And just finally, as to the demolition letter, that letter is necessary and preliminary to an action like this because, as was the case in Scheidel versus Pinecrest, in that case, part of the analysis from the court as to why demolition afterwards, after a successful 3215 challenge was appropriate, was because notice was sent prior to the developer who could have waited and decided not to, and therefore the remedy, the extraordinary remedy of demolition, was not inequitable. So it's absolutely necessary in a case like this, even if it's preliminary too. Thank you, Your Honor.
Thank you. That's our last oral argument of the day. Thank you all, and we'll be in recess.